often I will have people come to me and say, well, we're looking to repurchase the shares. And I will say, okay, well, the business is worth, you know, $500,000. And they're like, okay, we can pay that. We've got $500,000 on the balance sheet. I'm like, yeah, but the stock is worth $1 million
Right.
because of the money on the balance sheet.
If the plan owns 100% of the company,
Yeah,
it has to be liquidated. The company has to be liquidated to the tune of 100% to buy back all the plan's shares,
right,
right? I mean,
right,
there's no other way to do it. So
right.
all of that money has to come into the company to replace the plan's investment,
Yeah.
to redeem, which is daunting. I mean, not undoable by any means,
Yeah.
but daunting.
There are other times where people are very invested
Yeah.
in saying, well, I really, unfortunately, I unfortunately hear this a lot because it tells me that people don't understand what their duties are. But I will hear people say, well, I'm looking to repurchase the shares, and I would really hope that the shares are have a low value.
Oh,
Um,
yeah.
and and that unfortunately is tells me that the person doesn't really understand what they're doing in terms of what their duties are to the shareholder.
I get it, what you're saying, but it's the redemption dilemma, right? For the
Right.
plan owned company has to, in the absence of some other form of de-robsifying, to redeem stock, the company has to pay cash for that stock,
Exactly.
and it's awkward to know number one that you would have to liquidate all of the company almost, and replace all of that equity with some cash to fund the
Hmm.
redemption. And
Yes.
also that how expensive it is. But what you're really getting at is that people don't often understand that this is their retirement plan investment that they should hope is worth a lot.
I think most people are attempting, I don't know if they mean to do this going in, but most people are trying to arbitrage their
Yeah.
retirement
Yeah.
plans. I've had people who are doing things completely differently, and that's fine. But
Yeah.
in most instances, people, well, they're looking to um, create the best thing for them right now.
Yeah.
And
Right.
yes,
Right.
yeah,
It's understandable that they
right.
see the very short term of some of these answers. The way I remember the life events that can affect a ROBS plan are by calling them the 4 Ds, and those are death, disability, divorce, and disputes. So, in particular, this relates to the fact of when the ROBS owner is married and they might get divorced after the plan has been adopted and the company's operating. The ROBS owner could die or become disabled and no longer able to work. And then the fourth D is disputes. This happens when there's more than one ROBS owner or more than one investor in the company. Maybe both of them or all of them are ROBS owners. Maybe some of them are ROBS owners and some of them are individual investors. But I'm talking about this separate from married people. I'm talking about co-investors in the company. What happens when they have a dispute? It could be the most legitimate dispute in the world, that they simply disagree about how the company should be operated. They have disagreements with each other about how the company should grow. There's all kinds of opportunities for disagreements in any relationship, and if it happens in a ROBS context, it can be really damaging to the health of the company.
I think as far as disputes go, we'll start. I know that was the last one you mentioned. I think divorce and disputes are probably the two that I have most exposure to that end up on my desk. I think the primary strategy is just making sure that you're discussing these things prior to having an event, talking about it in advance and really documenting kind of what is your strategy going to be, having something that you can refer to and say, we talked about if this was going to happen, we have a protocol that we're going to follow that's going to help us solve this. I know that
Oh,
that's not always practical, but that would be ideal.
excellent. And so to throw in my attorney's recommendation for such a document, in the case of the co-owners, that would be who are not married to one another, that would be a shareholder agreement. A corporate attorney can help you draft a shareholder agreement in your jurisdiction that will help you and your co-owners navigate issues before they impact the company's value. I'm going to give an example of something I've run across where franchise owners were two married couples started a yoga studio. One couple decided after about 18 months that they didn't like it. They didn't enjoy working in this context. One couple had to bow out, but there was no shareholder agreement. And I was involved in an advisory capacity for the plan, which I didn't have to take sides in the dispute, but there ended up being a dispute about valuation of the company. Just, it wasn't a huge issue, but it took a while to figure out, and it was expensive because they each had to lawyer up on each side. Each couple had their own corporate attorney advocating for their position after the fact, after the dispute arose, which was how much does this couple get out of the company for leaving? They wanted to leave. What is their stock worth? They hadn't thought to hire one corporate attorney at the beginning to write out a fair and square shareholder agreement about navigating such a dispute in the event such a thing arose. And a shareholder agreement can address all kinds of contingencies that are reasonably foreseeable and that are common. And corporate attorneys are familiar with these kinds of things and can help you draft something. You don't have to adopt a shareholder agreement before the corporation is formed. You can do it now if you're a ROBS owner with several partners.
So when you were
Divorce.
describing the dispute over valuation, that was the first
Yeah.
thing that I actually thought of, because that's usually, if there is a point of contention, I've seen it be surrounding, okay, we have these non-publicly traded shares. We can't just Google what is this share worth today. I tell clients all the time, hey, you could go to 3 different valuation companies and they're going to give you 3 different numbers, and none of them are maybe wrong. It's just a matter of, looking at the approach. So I think that as far as divorce goes, if that's something that's, part of a conversation that's happening in your life, again, talking to your third party administrator and helping them understand the things that you need to know that may be able to help the conversation from getting too far down the line without somebody understanding the unique kind of parameters that you're going to have to navigate with the business because of your funding strategy. So again, what the first thing I always say is, make sure that they know that the retirement plan is a shareholder, because a lot of times they'll just go, well, I'm the only shareholder. Well, that, I know what they mean, but they have to say it exactly, the technical way, which is the retirement plan is involved. So if we start talking about, there's only one participant, but the husband and wife have always made decisions together, and that was their intention.
Right.
Understanding if the business is going to be split in some capacity, you're splitting it from inside the retirement plan. And a lot of times that's not necessarily what happens, but just having that fact out there. And then also, I always, in that kind of conversation where we go, okay, what do I need to know? Just understanding that if retirement plan assets become a part of the assets that are being split, that is done with a court order that is not the divorce decree. There's a qualified domestic relations order. It's a specific type of court order that is used specifically to change the taxpayer associated with the retirement plan assets. So there's reasons and motivations as to why you may want to try to avoid the a quadro is the acronym we use. And then there's other times where it makes a lot of sense, and you're going to want to work with your third party administrator to make sure that that court order is approved. All the language is exactly the way they need it, because I've had clients going through a divorce. They send me a quadro that is already signed by the judge, and it
That's not
doesn't meet all the
appropriate.
parameters for me to be able to process that transaction. So then it's more attorney fee. They have to go back in front of the judge. Who knows how long that's going to take to get signed. So I always ask to get a proof before it goes to the judge, just to kind of get that last check of, yes, this language has been approved. There's nothing that's left up to interpretation that we would be concerned about.
Yeah, the TPA is as the outside administrator of the plan assisting you, ROBS owner. It has a legal duty to handle plan assets very carefully in accordance with the terms of the plan document and in accordance with all of the applicable rules. So if the quadro, that's the qualified domestic relations order, if the quadro is not written just so, as Holly said, the TPA will not have the legal authority to implement it. So it needs to be drafted properly before the judge signs it. The other point I wanted to make about the disputes, death, disability, and divorce is that when there's a surviving co-owner after, or the company is expected to continue after one of these life events, one thing that you should just be prepared to consider is that the value of the company may be impacted financially by the loss of that key person who is now out of the picture. So in the case of a divorce, if a spouse has been helping her, let's say the wife is not the ROBS owner, the husband's a ROBS owner. The husband is the one who has legal title to the assets. He's inside his plan account, but the wife has been working hard to help the company succeed. If they break up, the wife is no longer adding that value to the company, and that can have an impact on the company's revenues and prospects and value. So not only the actual legal mechanics of breaking up with the plan account, that's what we've been talking about so far, but also the value can be affected by the loss of that key person who may not have been employed but has been actually helping the company succeed. This happens with co-owners who are not married, such as friends who start their company together, and then they have a dispute. One of them's out of the picture, and they're no longer. They might, long before the legal effect occurs, the person may not really be working hard to make the company successful. That can actually depress the value of the company. That's why a shareholder agreement has some money attached to it. You're creating a shareholder agreement with the idea of preserving value for the company in such an event as a dispute, for example, or a divorce. This is very, very sad. I've come across this many, many times as an ERISA attorney advising ROBS plans, and that is that the widow of a ROBS owner who has died, where there's a successor owner as well, co-investor that has not died. There's a surviving co-owner and the widow or widower. That widow or widower is probably more interested in getting some money out of the company than they are in helping the company continue to succeed. And so the death beneficiary, the widow or widower, becomes the ROBS co-owner of their decedent spouse's shares instantaneously upon the death of their spouse. This doesn't have to go through probate. This has nothing formal other than the death of the ROBS owner instantly creates a new ROBS owner who is the death beneficiary under the terms of the plan. In most states, by default, that's the spouse, if there is a spouse, or it could be however the state law works to create a death beneficiary if the person hasn't named a death beneficiary. But whoever that person is, they become the ROBS co-owner with that surviving ROBS owner. And the surviving ROBS owner may have no desire to have a co-director in the company that they don't know, who has no interest or skill or desire for the company to succeed. They simply have assumed this role because of the death of their loved one. And then keeping in mind that both parties are probably grieving the loss of their their co-owner, partner, and spouse. So you've got two very emotionally, people who are in emotional crisis, grieving the loss of a key person, and they're going to find out that the value of the company is severely impacted by the loss of that key person. So the solution for death, to prepare in advance, is for the company to buy key person life insurance. This is a life insurance policy on the life of the co-owners, and the company pays the premium and is the beneficiary of the premium. That pot of money can be used to buy out a widow or widower so that they are no longer associated with the company, or it can be used to hire a person to pay for the salary of a new person who has to be brought in to sustain the value of the company by replacing that key person who has been lost. I think it's worth considering, as unpleasant as it is.
I have had personal experience with people who have had some sort of key life insurance policy in place, and I have personally witnessed that it does make things a little bit more smooth, and it helps kind of make sure that the company has a little bit, it can absorb maybe a little bit more while it's going through a transition. But I will just add, for all of the listeners, one thing that everybody should write down and go do immediately as it relates to this is make sure your TPA has an updated beneficiary designation form and it's signed. And I think in addition to that, making sure that your beneficiary knows that they are the beneficiary. Like I said, a lot of times when you're going through these hundreds of pages of documents when it comes to adopting a retirement plan, that's one of the things you have to complete. But you would be surprised how many times that doesn't get sent to the TPA. Something happens and we look and it's like, okay, it's either here if they completed it, and then we have to operate without, and that's never easy. So go call your TPA, ask them if they have it. If they don't, get it from them, complete it.
I have to check myself, because I don't know. I don't recall filling one out in May when I adopted my plan, and I have to go find out. Thank you for that tip, Holly. I will be doing that.